And good afternoon, Lord Deputy Assistant Public Defender, with on behalf of Mr. Merriquin, who is here to my right.
All right. Your name, sir?
David Merriquin.
Thank you. Ms. Yagi, your motion.
Thank you, Your Honor. We are asking for reduction in Mr. Merriquin's bonds. I won't go into all the detail I did in my motion. I'll just mention a few things.
This hearing opens with something you almost never hear a judge say so directly. I want you to be a success. That immediately tells us this isn't just about punishment. This is about rehabilitation versus risk. We're stepping into a bond reduction hearing where the defense is arguing that the defendant has changed significantly during incarceration, stabilized on medication, connected with a sponsor, sober network, family support, and structured planning. But here's the tension. Courts hear promises of change every single day. The real question is, how does a judge separate rehearsed redemption from real transformation? Watch closely for consistency, accountability, and whether the defendant takes ownership without minimizing past failures. Also pay attention to how the judge tests honesty. Experienced judges often ask questions they already know the answer to. That's not casual conversation. That's credibility testing. So as you watch this unfold, ask yourself, if you were on the bench, what proof would you need before granting release?
Recently, obviously, I know the court's well aware he's been in jail for quite some time, and the biggest thing that I wanted to highlight today are the changes that have taken place during his incarceration. I think one of the biggest ones is his meetings with Inmate, his medication. He's now stable on his long-acting medication, injectable. I've been in touch with his sponsor and his parents, all of whom are very supportive. His sponsor told me that he has a great network of people. His sponsor's name is Patrick, and Patrick told me that both Patrick and Mr. Merriquin have a network of people, a sober network of people. There are meetings that I know Patrick attends at the Alano Club weekly. There are also Zoom option meetings that they've been talking about. I know Mr. Merriquin has interest in going to the Alano Club for the meetings with Patrick, weekly meetings. And the other thing that I just want to highlight, because I just spoke with his parents again, well, his mom again today, and his mom told me that she notices the difference in the way that Mr. Merriquin is speaking in terms of, ironically, his mom said that when he gets out, he needs to come up with a schedule. He needs to come up with, you know, this is what I'm going to do today, and this is my business I need to take care of. And she's already been talking to him about that. And she told me that Mr. Merriquin is actually nervous about messing up, and he actually really wants to do what he's supposed to do. And she told me that that's a difference, because if he really is motivated and nervous and wanting to prove that he can do it and he will comply, she thinks that's a good sign. And so she, that's something she shared with me today. And she basically has been talking with him about that, that plan moving forward. He has a social worker at his apartment who I verified actually would come to him. So if he's released, I said, where would you absolutely need to go if you're released? And
this is a critical turning point in tone. Notice how the judge pauses the procedural flow and speaks directly to the defendant about visible change. That matters. Judges observe demeanor over multiple appearances, posture, clarity, responsiveness, emotional regulation, and they absolutely factor that into bond decisions. The defense highlighted medication stability, sponsor contact, structured meetings, and parental involvement, and now the judge confirms she personally sees a difference. That creates judicial confidence, but it's not enough by itself. Courts don't release people because they seem better. They release when supervision conditions can manage the risk. Let me ask you something. Should visible improvement carry heavy weight in bond decisions, or should only objective compliance history matter? Because what's coming next will test whether this change is surface level or deeply internalized.
And it's his apartment. His social worker could come visit, or social worker, caseworker, whatever.
Yes.
Yeah, would come to his apartment to sort out his housing issue, try to, get that payment, get that sorted out. And then, that would be step one. And then the meetings, would be step two. But it does seem like he is in a much better place now than he was previously.
All right. And his housing is in place?
His apartment is in place. His mom was there this week, and, yes.
All right. Response. All right. Samariquin, it's like you've been here forever.
I could take a.
Now we're at the most psychologically revealing moment of the entire hearing. The judge asks a deceptively simple question. Do you think you need home confinement? That's not about logistics. That's about self-awareness. Many defendants sabotage themselves right here by insisting they don't need restrictions. But listen to what happens. He admits he does need it. That's huge. From a judicial standpoint, voluntary acknowledgement of limits signals reduced supervision risk. It shows insight into personal triggers and past failures. Even more important, the judge explicitly states that the old version of him would have lied. That comparison is powerful in credibility assessment. Courts look for insight plus honesty plus support structure. Quick question for you watching. Would you trust someone more who asks for stricter rules to stay on track, or someone who argues for total freedom?
Yeah. Yeah. As Ms. Yagi was talking and arguing, and she was talking about the differences in you. A lot of times people think judges are sitting up here and they don't notice differences in people, and I notice a difference in you. There was a point where you came in, and I don't know if you recall this, you had actually been before me on something else.
Here comes the legal mechanics. The judge structures a PR bond with GPS home confinement, and that combination is very intentional. A personal recognizance bond means no cash is required up front. Release is based on promise and conditions, but GPS tether adds real-time accountability. This is what we call a supervised liberty model, freedom with enforcement. Notice also the judge requires a written behavioral plan from counsel. That's not routine in every case. That's a rehabilitation roadmap requirement. It shifts release from passive to structured. The court isn't just saying, don't mess up. It's saying, show me your system for not messing up. Do you think more courts should require structured reentry plans before release? Because this judge is clearly trying to engineer success, not just hope for it.
You then came before me that time, and I'll just tell you, you were in bad shape.
I've had plenty of time to stabilize on my meds, get right with my 12-step program, and basically make myself fit for being on the streets, because honestly, I wasn't before.
Yeah.
I was right where I was supposed to be good.
Yeah.
And right now, it's like, I feel like if I'm released, whatever the conditions are, I'll be able to meet them because I'm competent. And
Watch this scheduling adjustment. It's more strategic than it sounds. The judge adjourns the preliminary exam date, but keeps the same exam judge. That preserves procedural continuity while buying time for stabilization and planning. Timing in criminal procedure is leverage. It allows defense counsel to gather documentation, treatment verification, compliance plans, and possibly negotiate resolution. The judge is essentially creating a controlled runway for success while keeping oversight intact. Also notice how the defendant asks clarifying questions. That's another positive behavioral indicator. Engagement instead of passive nodding. Audience question for you. Should courts build more structured transition periods like this before major hearings, or does delay risk accountability?
sober, and I'm working the program.
All right. How many AANA meetings do you go to?
I prefer to go every day, but if I'm on home confinement, I could see shaving that number down just a little bit because it's kind of hard to get a hold of Mr. Casey every day,
Right.
I just kind of leave to go to my meeting or wherever I want to go whenever I can get a hold of him.
Let's professionally wrap this up. The court grants release on a $225,000 personal recognizance bond with GPS home confinement, delays the exam date, and orders a structured compliance plan. The decision rests on 3 pillars: observed behavioral change, medical and sobriety stabilization, and verified support systems. Most importantly, the release is conditional. Success is expected, not assumed. This is a textbook example of a judge balancing rehabilitation opportunity with supervision safeguards. It's neither blind trust nor automatic detention, it's managed risk. Cases like this show how honesty and self-awareness can materially change outcomes in court. Now I want your take. Was this the right call or too risky? If you found this breakdown helpful, make sure to hit like, share your opinion in the comments, and subscribe for more high-impact courtroom analysis and real case breakdowns.